Good afternoon. The Electricity Act consolidates all the laws on electricity in Nigeria. So it's a very robust document. And for me to speak around it in 10 minutes, you'll be patient with me. Thank you. Good afternoon, the chairman, SLP, chairman, organizing committee, Leonard Silks, my learned friends, ladies and gentlemen. I have prepared slides. If you could just project them so that within the 10 minutes allotted to me, I will just maybe go through one or two of the slides and then highlight some of the opportunities that are available to lawyers under the Act. Before the slides are projected, I just want to highlight the importance of electricity. Electricity is the engine for development in a modern society. If there is no electricity in this room, something will happen quickly. One, we may not be able to see each other. You may not hear me. And the environment, the temperature may not be comfortable for us to stay longer in this room. That just underscores the importance of electricity. And it extends to schools, to hospitals, to offices, to factories. There is no how a country will develop if it doesn't get it right on the important issue of electricity. Thank you. Thank you for projecting the slides. And before I start speaking to the slides, just to emphasize one more thing. As important as electricity is, you would think that government is best positioned to carry that responsibility. I mean, if it is so critical for any society, then let government be responsible for providing such an essential service. Unfortunately, the government cannot do it. Why is it not possible for the government to do it? Because it is very, very capital intensive. It is very expensive to generate, to transmit, and to distribute electricity at a utility scale level. I'm sure some of us have generators, we have solar panels, and you know the cost. So what are we left with? We are left with private investors. We have to, as a matter of necessity, migrate electricity from a social service to a business that will attract the needed investment. And if such huge resource is needed, financial resources is required for an important sector like that, and you are leaving it to private sector, then you have to have a very strong legal and regulatory framework. If you don't get it right on the legal and regulatory framework, which will form the basis for investors to bring in their money, then you will not get it right. You will just continue. And that underscores the importance of this law that has recently been passed. So I will be going through the slides. Maybe I will just emphasize one or two. The first thing, we all know it was passed in June. It's quite recent. It repealed the electric sector the Electric Power Sector Reform Act of 2005. That act was very instrumental in providing the basis for privatization of the electric sector. However, there has been several challenges, and it has become clear that that law will not take us to where we need to be. And so it's been repealed, and the Electricity Act 2003 has now been enacted. I will just mention one more thing on this slide that we are looking at, which is that part of what the Act tries to do is to provide a framework that will incentivize investment on renewables. Now, why I'm saying this is because you are going to be hearing, and some of us may have been hearing, the point about energy transition. In 2015, Nigeria and several other countries signed the Paris Agreement on climate change, and that there are national determined goals for each country to reduce the greenhouse, emissions and to decarbonize. And there's a target that by 2050, I think Nigeria signed on to, Nigeria, Russia, Saudi, and other countries signed on to 2060. There is a target that by 2060, all energy will be clean energy. We will not be sourcing our power from non-renewable sources, which emit carbon dioxide into the environment. Currently, Nigeria's energy mix is majorly non-renewable. It's majorly carbon mix. You have 80% of our energy source from gas, and then maybe 17% to 20% from renewables. And the renewables are the traditional renewables, which is hydro, hydro dams, which are the traditional. You need to upscale to solar, to wind, and other modern forms of renewable energy for you to scale. So that's why this act, I just thought to mention that this act, acknowledges the fact that energy transition is real. Nigeria needs, to be part of it. Is my time over already? Oh, wow. Okay, so my time is up. I will just go to the last slide. Can you go to the last slides that talk about opportunities for lawyers? Okay, so just go maybe 2 slides before this. All right. So what are the opportunities for lawyers? Quickly, there's an opportunity for legislative drafting. Why is this necessary? Because the Act allows for states to have their electricity markets. And for them to have that, they will also need to enact their laws. There are some states that have their laws, but that's not enough. They will need to amend it, in line with the current realities. Lawyers will also need to provide advisory services for states in setting up those markets. There will be employment opportunities. Once you have an institutional framework, like a state NERC, like a state regulatory authority, the legal, the licensing, the compliance will have to be handled by lawyers. So that's an opportunity. There will be opportunity for you to structure PPP and JV arrangements. States will have to enter into JV and PPP arrangements with private sector players and investors. And lawyers will have to provide the legal structuring for that. Regulatory licensing, you need to support investors, capacity development, and several other investment opportunities that are there for lawyers. Thank you very much.
Thank you very much, Cephas. I'm certain the slides are available and will be made available to conferees. Now, we come now to session 4, our last session before the Young Lawyers debate. And that session is on tyranny and dictatorship of election petition. Where is justice? We'll be calling on the panelists, beginning with the chair. Mrs. Nella Andemewa, Senior Advocate of Nigeria. A round of applause for her. She is the chair of this session. Please come round. purely from, without any, in no particular order, Mr. Mazi Afam Osigwe, Senior Advocate of Nigeria. Your names are by your seats. Mr. Chukwuka Ekwazom, Senior Advocate of Nigeria. Dr. Orohuo Okocha, Esquire. I believe Mr. I'm correct? Okay, yes. And Tobena Erojikwe, Esquire, who joins virtually. Chair, I yield to you, sir.
Good afternoon, conferees. Good afternoon, council members. The expectation was that there was going to be an introduction of all the eminent speakers that are here today. Can Mr. Olasi, yes, can you that was what we agreed. And I said I would allow you do that so that we are familiar with. Yes.
Distinguished conferees, I've been directed to once again introduce the panelists. The chair of the section is the past Attorney General of Cross River State, and during her tenure, she became the first African female to address the International Court of Justice as counsel. Elana Silk is a live venture and a member of National Executive Committee of the Nigerian Bar Association. She is also on the board of numerous private and public companies. Please welcome Mrs. Nella Enda Ewa Rabana, Senior Advocate of Nigeria. We have gladiators in the house who will do justice to this topic. Sitting next to the Nana Silk is the past General Secretary of the Nigerian Bar Association and the past chair of the Unity Branch of the Nigerian Bar Association. Please welcome Mr. Afam Osigwe, Senior Advocate of Nigeria. Just like him, also a past chair of, they claim they are the largest in the country, the past chair of the Lagos branch of the Nigerian Bar Association, Mr. Chukwuka Ekwazom, Senior Advocate of Nigeria. I have virtually, because we are talking about practicing law without borders, I have currently the current chairman of Nigerian Bar Association Continue Legal Education. He is a partner at the law firm of Crest LLP, Mr. Tobena Erojikwe, Esquire. Then last but certainly not the least is one of the Port Harcourt finest when it comes to the business of law. I can testify for that. Is somebody that is assistant managing solicitor at the law firm of Okocha and Okocha based in Port Harcourt, a skilled arbitrator and litigator. He is a lecturer at the Faculty of Law, Rivers State University, Dr. Oroho Okocha. Please give a round of applause for him. Mr. Chair, over to the...
Thank you very much. Just so that we set the tone, I would remind us of the topic today, which I believe for different people, their reactions may be different, their perspectives may be different. The topic is tyranny and dictatorship of election petition. Where is justice? I know that when I saw the topic initially, I wondered, which way should we go? But then, looking at the concept note, and of course, because of the, oh, this is not working. Oh, okay. Thank you. I noticed that there are different perspectives, and by virtue of the hand-picked speakers, I'm excited because I believe that we're going to do justice to this topic. So that I don't preempt them, I would only read I would only read an observation. They said, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut that presumption.
I would have to stop at this point. Thank you.
Thank you very much. I'm sure you're not surprised. Indeed, Chief Afam Osigwe has spoken primarily about judicial decisions and whether or not some of the decisions do not cause people to wonder whether it is not tyrannical, whether it's not a dictatorship. He has also mentioned about the umpires, he's mentioned about the political parties and their impact. Please, if you have any questions, because ultimately there's going to be a question and answer session, please kindly note it and note who you would want to answer the question. And then you could give it to one of the organizers when you find them. And whilst that is happening, I'm going to call on Mr. Chukwuka Ikwazom, Senior Advocate of Nigeria. Please take the floor.
Thank you very much. Good afternoon, distinguished colleagues. I thank the leadership of the section on legal practice and the organizing committee for this conference for inviting me to share my thoughts on this very important topic. We're discussing the tyranny of election petitions. I've decided to look at it from a slightly different perspective. So my understanding of the topic is that the framers of the topic believe that an inordinate amount of judicial time and resources are allocated to election petition cases, politically related cases, to the detriment of other equally important cases before our courts. So my starting point is to answer the question whether this is justifiable or not. And I think it is. I believe that pre and post election disputes are sufficiently important for us to prioritize them. As a matter of fact, my view is that no one who has contested for office should be sworn in before all disputes relating to that person's election have been determined. That's my view. So the question then is, what is wrong? And I think that in interrogating what the problem is, we need to look at two things. The first is, why do we have so many political cases in Nigeria? I stand to be corrected, but I do not know any other country within and outside of Africa that generates the amount of pre and post election litigation that Nigeria generates. What is responsible for that? I'll try to give my perspective on what I think is responsible. The first is, we have a crop of very desperate politicians who are willing to do whatever it takes to attain political office. The second is that some of these politicians, especially those of them who are saddled with the responsibility of enacting electoral laws, because they want to, preserve their selfish interests, every time that they amend the electoral law, they do things that will make it easy for them to continue to rig the process. So today we know, I don't do election petitions, but I know that there is an almost insurmountable burden on a petitioner who wants to overturn an election. Again, our courts, our judges, with the greatest respect, have managed either deliberately or inadvertently to send the message to politicians that they can do anything and get away with it. So what you find is a situation where people are willing, because they know there are no consequences, they are willing to do whatever it takes to attain political office. And I'll tell a real life story. A few years ago, someone mentioned to me that a very senior lawyer who does a lot of election litigation was calling the incumbent governor of a state on the eve of the election, almost frantically. He didn't get through to the incumbent. So he spoke to the Attorney General. And the message he had for him? Tell His Excellency to do whatever it takes to be announced the winner. I don't want to be running through the courts trying to overturn someone else's election. Now, with this kind of mindset, it is not difficult to see why every season, every election season, we have an inordinate number of election-related cases. So I think that that's what the problem is. It's not really the fact that we are prioritizing election petition cases, because I think we should. The second point is that our court system, even without all the issues with election petition, our court system is totally dysfunctional. Totally dysfunctional. So even without election petitions, how efficient and how effective is our court system in settling simple commercial disputes? So a combination of these two factors is actually what I think the tyranny is about. That's the reason people feel that, we devote an inordinate amount of time to election-related cases to the detriment of the other cases. What do I think are the solutions? I think that first and foremost, we need to reform the electoral, the judicial process in Nigeria. A few years back, when I was chairman of the NBA Lagos branch, the branch set up a judiciary relations committee that was chaired by Mrs. Funka Adekoya. That committee worked with an NGO, an initiative called the Comedies Lawnet, and they came up with an administration of civil justice bill. Only 2 states in Nigeria have enacted that bill, Ekiti State and the Delta State, when Isaiah Buzimo was Attorney General, right? A lot of the proposals or propositions in that bill, I think if we're able to implement them, they will help solve some of the challenges that we find in adjudication of disputes. So, for example, we're in the 21st century, and a lot of our judges still record proceedings in log hands. There's a proposal in that bill that heads of courts should license transcribers who will be transcribing judicial proceedings. But my experience is that it's actually, you would think that judges would embrace this because it makes their work less tedious. But it's actually the judges who are opposed to, this kind of transcription of proceedings. So my point is that there are many things that we can do to, solve the issues we have with administration of justice to make it work better. I also think that we should consider, appointing retired judges who are still able to sit over some of these election petitions. There is no reason, honestly, why we can't select from a pool of retired judges to handle these matters, to avoid a situation where, we are assigning those cases, at least at the first instance, to 7 judges, with the fact that they are not able to attend to all the other matters they have. So I think I will stop here and let the other panelists give their own views. Thank you.
Thank you very much, Mr. Ikwazom SAN. From the reaction, you can see that there's a lot of agreement in the room as to your perspective. But let me just summarily tell you some of the high points. First, the question you asked, is it justifiable to more or less compromise other aspects of litigation because of political cases? And you gave your reason why it should be prioritized, but at the same time, you also gave the reason why it appears that we have neglected, or we are in the process of neglecting other aspects of litigation. You also talked about the mindset and how efficient the court system is and its impact, negative impact on the outcome, which ultimately makes one wonder whether the election tribunals, election petitions are not tyrannical. Now, if you have any question, then you did speak about the appointment of retired justices, maybe judges as well, but that's food for thought. Now, before I call the next speaker, who is going to join us from, is it Port Harcourt? Oh, he's in England. Who is going to join us from England? That's the beauty of technology. I can see him. Okay. So before doing that, please, if you have any questions for Mr. Chukwuka Ikwazom SAN, please note it and also give it to the organizers because, we are definitely running out of time. So let me invite Mr. Tobina Erojikwe, Esquire, who will be joining us from England to give his own perspective. Good evening. Please, audio.
Thank you very much, Chairman. I'm very grateful to the Section on Legal Practice for inviting me to speak today on this very important topic. My understanding of the topic also aligns with the understanding of the Leonard Chukwuka Ikwazom. prioritization given to election petitions appears to reduce the or diminish the importance that attach to everyday civil litigation and criminal litigation matters. I don't quite agree that we should over-prioritize election petitions. Yes, they are time-bound. Yes, it is important. Yes, it is something that affects not just the politicians, but the entire system, administrative and democratic. However, it does appear to me a bit strange that rights of individuals who are facing criminal prosecution are also, compromised as a result of the emphasis that we pay to these election petition matters. And that there are also certain very sensitive commercial matters that suffer as a result of this. It does appear to me that from a corporate cognizant level and in its totality, we haven't given enough consideration to the effect of election petitions on the entire judiciary framework. Because if we have, I think that we should be able to accommodate everything. And it's important to make the point that it is a realistic problem that confronts us, that we don't have enough judges in Nigeria to deal with the cases that we have. So this is quite apart from the inefficiencies that are inherent in the system. But I think that primarily the dockets are so filled up that it is a stress and a problem for the judges to deal with them. So that even if you remove the election petition matters from the entire conversation, we still have an impossible judicial system that we cannot defend with the various clients that we work for. So whenever international clients ask us for a due diligence and they ask about how long it takes to determine matters in Nigeria, and all of that, and the kind of decision making you expect, you find that we generally struggle with that. So I think that we have a huge, huge problem with that, and it's something that cannot be resolved by the judiciary alone, or by the executive alone, or by the legislator alone, but it's something we have to look at comprehensively. If you look closely at the entire electoral system and framework, I don't think that it's enough to blame just the politicians. I don't think it's enough to blame just the judiciary. What about the lawyers who take up those matters that are clearly frivolous? What about the individuals who actually help to defraud the electoral process? So I think that it's actually a clear manifestation of the kind of people that we are as Nigerians, that you have the kind of system that you have. I mean, many years ago when I was working in England as a solicitor, I was involved in electoral matters. And I can tell you that it was very seamless, very easy. We didn't even have anything electronic. People vote. At the end of the day, you go to your council, results are called, people congratulate each other. So why you would have 10, 12 applications in court over a gubernatorial contest or a House of Reps contest or is something that's difficult to understand. And you find that indeed the politicians and even the lawyers that represent them go to court sometimes for other reasons other than actually getting a determination in their favor. Sometimes it is for them to get some form of settlement from the other people because it will cost less to litigate the matter than to settle them and for them to walk away. So when you look at all of this, you ask yourself, what are the solutions? I mean, there are many solutions. If you look at the UWEA's report, UWEA's report dealt with a number of these issues, and I want to suggest that we should go back to that report and implement it in its totality. Because again, once somebody is sworn in before the matter starts or while the matter is in court, it gives him an inordinate advantage. So what you find is that everybody is saying the man is already in government, let him share money to us, let us go. And then all of that continues. But there are so many things we can do. I don't know why most electoral matters should go up to the Supreme Court. Why can't we revert back to a time where we had pre-election matters stopping at the Court of Appeal and also matters that are not the presidential elections also stopping at the Court of Appeal? So you reduce the pressure on the Supreme Court. But whatever you do, you simply have to employ and appoint more justices. The idea of having senior lawyers involved in election petitions, or even in other adjudicatory processes, as you have in other places in the world, either as recorders or as actual temporary judges sitting in these matters. And the idea of having also retired judges. But the problem with retired judges' idea, say, is also the fact that we now have a 70-year-old threshold. So if you start from 70-year-old, you find you struggle to get many people who would be strong. But right now, I think it's a policy we can adopt in order to make things more efficient. The other thing is that I think that we must think of costs being awarded on an indemnity basis. So that, and people actually having to have an indemnity bond in place if they're actually going to litigate on election petition matters. Because this will actually incentivize those who are going to court frivolously. So that's my opening gambit on this. Thank you.
Thank you very much. Again, that's another perspective. And of course, if you have any questions which you would like to direct to Mr. Tobina, please note it and give it to the organizer. Just by way of summary, he did agree that election petitions are important, but he didn't feel that it should compromise other aspects of litigation. He did also mention the fact that there could be a comprehensive solution, but we should not target the blame only on the courts and the judges, but rather we should look at all the parties involved. He did suggest that we should go back and look at the Uwais report. As a matter of fact, there are other report sources that we could look into, which I think has triggered the reasoning. And finally, he talked about the indemnity. If there was an indemnity clause or responsibility of all lawyers, which I wonder up till now, because this is an old matter that has been brought up severally. Why we have not put it into action, I do not know. Because, of course, if you are paying an indemnity, if you're paying indemnity in your practice, you would think twice before you show up, because you'll be held financially liable when it is frivolous. So I would move to the next our next panelist, who before we came in, we agreed that peradventure we do not collate and figure and prefer solutions that cover the field. He would take that responsibility, and his name, of course, is Mr. Dr. Oroho Okocha. Of course, I know Okocha. Please, can we give him a round of applause? So, Doctor, you have the floor.
Thank you, Chairman. I don't know if my microphone is working. Thank you, Leonard Silk. Before I go into my paper or into my thoughts, may I just say that if I had put my thoughts down on paper, I might have suspected that Tobina had read my paper before he brought it, because he has touched on pretty much everything that I intend to touch on. I will also start by, or I also like to answer your question, Leonard Silk Ikwazom, that, or I disagree with you. Election petitions should not be prioritized. For the students who are here and for the boy in me who dreamed of becoming a lawyer, I always ask, is it more ideal to determine whether A killed B or determine whether A won an election? Is it more important to handle a commercial transaction involving a gas pipeline? Gas doesn't stay in one place. Gas evaporates quickly. Is it not more important to do that than to determine whether A won an election or not? But as we said, and if you have ever spoken to me, I believe that going straight to the issue, the solution to our problem, like Tobenna said, if you remove election petitions from the table, our judges are already overworked. If every matter is able to be heard within a reasonable time, there would not have been the need for it to have been statutorily mandated that election petitions be time-bound. Because as a matter of nature, as a matter of course, matters will be heard and resolved within time. I had all the statistics and I presented them in Asaba last year that the Federal High Court has over 120,000 cases with 75 judges to deal with. A judge in Rivers State, on average, deals with 400 cases. A judge in Lagos deals with over 600 cases. Yesterday, I asked my Lord Justice Kio, who was on the Premium Showcase session, and he gave me an exact figure. 767 cases are the number in his docket. When is he going to hear all those cases? When is he going to determine all those cases? Then you add the inordinate number of cases that are filed as election petitions every day. I'm not going to waste time talking about the problems, but I will stress the fact that I have a simple matter where I only intend to call one witness. Since February, it's been adjourned to November because the presiding judge is dealing with election petitions. In an ideal world, if we could have gotten judgment within a month or within 3 weeks, she would have heard that matter before she proceeded on election petition. So my solution, or what I think we need to, as a profession, sit back and criticize is, how long does it take to determine a case? And how long will it take us to clear the number of cases in our registry? The High Court of Rivers State, at its opening year, every year, the Chief Judge reads out statistics. And he always says, last year, we had disposed of 5,700 cases, nearly 6,000, but there were still 11,000 cases pending. If we stop time and we don't file any new cases in Rivers State, they still need 2 years to clear that backlog with the number of judges they have. So I say that we go back to the drawing board. Every judge seated here knows how many hours they need to read and determine. All the reference to technology and to case management and to having retired justices come on board still does not take away from the fact that human intervention is needed to determine cases. So even if you fast track, all you are improving is access to justice. So rather than prioritize a set number of cases, rather than prioritize a set number of days to determine certain matters, work out the logistics. If 35 judges in Rivers State can only dispose of 6,000 cases, get 70 judges. Simple arithmetic. They may more likely dispose of 10,000 and more. Because at the end of the day, if you think of litigation as a business, you want the same number of cases that are brought into your courtroom to be disposed of within the quickest possible time. I was watching a TV show the other day, and the person being interviewed on the TV show was giving an insight into his life. He's an American, and he said, he had dabbled into legal practice and had practiced law for 2.5 years. And he didn't get that much work done. He only tried and concluded about 9 cases. But it actually struck me. A man is saying that in 2.5 years, he was only able to dispose of 9 cases. Let us ask ourselves the truth. How many of us have commenced and concluded a single case within 2.5 years in our current climate? So I think the simplistic solution, work out the number of hours you need to determine one case. Multiply that by the number of cases that you currently have filed in your registry and you anticipate will be filed throughout the period. and then divide it by the number of hours that you need to solve that problem and resolve all those issues. There's always the kickback when you talk about more judges, when they say, oh, you will need to spend more money, you will need to build houses for more judges, you need to buy more cars. But every one of us who is in business knows that there is a simple rule of life. You must spend money to make money. So employ more judges. They will dispose of the cases. If you look at jurisdictions in America, I think the state of Minnesota, they have occasions where an actual sitting judge of the high court, or their district court as they call it, is free. He has cleared all the cases in his docket. So when a new case is filed and it's a complex case, it is that district judge that's called upon, because in the mind of the administrator of the court, he has more free time and he can more quickly deal with the situation. So let us think of the problem of election petitions and our judicial system on the whole as being a problem of a shortage of manpower. If you have judges that are able to conclude their cases before election season comes around, when those cases are filed, I'm free. So give me those cases, I'll do them. Even if we know that we have judges that are employed and as part of their contract, maybe 5 judges are told that you will serve on the high court bench, but you will also be a election judge when the time rolls around, almost like secondment. Those people also will manage their cases well enough so that everything is handled and resolved within the quickest possible time. So for me, I continue to say and I continue to ask, why are we focused on other things rather than increased manpower who will get the job done? So that is my solution. As the concept note says, justice delayed is justice denied. Even without prioritizing electoral matters, justice is already being denied every single one of us. So I thank you for your time, but that is my submission.
Thank you very much, Doctor. We have come to the end of the presentations, and although I didn't catch the Pythagoras theory on how many lawyers and the time and all of that, but I think the basic principle here is if you want the job to be done, you need to have more judges, justices that can cope with the work. I know that you didn't talk about their competencies and how they are recruited, which has always been the problem. It's not the only problem, but it is central to that issue, which is why in recruiting judges, justices, it's an issue. I think the logic of what you're saying, in a nutshell, is that you need more judges, you need more justices. So with that, I think if there are any questions, please can we have them? I know you've been here all day, but like was said at the beginning, this is it's topical, and I want to commend the organizers because it would have been such a shame not to acknowledge how important this particular topic is. So please, if there are any questions, I would like us to take them now. Thank you. Okay. Please. You know, the light is in my eyes, sorry, so I can't see you, but please go ahead.
Thank you very much. Good evening, everyone. My name is Etigwe Owa. Mine is not a question. I have a few comments. I think that we need to interrogate a few issues. One of it is, why do we have the amount of pre- and post-election matters that we have? And I think at the root of it is that the reward for public office in Nigeria is just too much. So people get into public office and they make so much money, much more money than businessmen. Once you still have that kind of reward system, you're going to have a situation where politicians feel is do or die. And if they lose, they must go to court. Second point I'd like to make is this. There is some kind of jurisprudence that is also encouraging the situation that we have. So our Supreme Court tells us that if you have a problem in a political party, it's internal and it's not justiciable, what you then do is that you tell political parties that they can act in any way with impunity and get away with it. And so there will be a Congress, somebody will write a list, and then when he writes that list, somebody else will be aggrieved, and then you have a lot of pre-election matters. Again, I think that one of the things that we should do is to even move away totally from pre- and post-election matters. There are countries where they don't have all these election matters, where if you have it, maybe once in 10 years, once in 5 years. Why must we have all these kinds of things? And the reason is because the politicians do not want a reform of the electoral process in such a way that it is transparent. In this day and age, there is no reason why in every polling unit you can have a video and ensure that these things are kept in such a way that if there's an issue, you go and recount. My time is up, I'm sorry.
Thank you very much. Thank you. I think the point, the session chair, please.
SAN is timing me, so I have to be very brief. The thing that amazes me is that we are doing the same thing over and over again and expecting a different outcome. That is insanity. We have tried this election system since the 60s. The same way, the same principles. And every year we are inundated with so many election matters. Things have to change. One, let's have constitutional courts. Our courts just can't cope with the volume of election cases. They cannot even cope with the volume of regular cases that are brought to them in the course of their duty. Now you add election matters. Two, the orientation of the average politician must also change. Nigeria is the only country I know in the world where 10 people will contest for an office, and all 10 of them will expect that they will all win. Other countries, it's a game. They expect that one person will emerge. So there's no acceptance of results. And number three, the law itself has to change, because to upturn an election in Nigeria is like the camel passing through the eye of a needle. It's virtually impossible. The principles you must get to prove, I'll just give two so that I can just save your time. To prove that there was no election in a particular area, you must call a voter from every polling unit. That's not possible. To prove that there were irregularities in a particular area, you must prove it polling unit by polling unit. So if you come and bring electoral documents and tender them, they will say you dumped those documents, that there was no proof, and so on and so forth. So we must go back to the drawing board and change the way we approach election matters. The politicians themselves must change. The court system has to change. Otherwise, we'll keep having this outcome every election year. Thank you very much.
Thank you.
Chairman and Chair of the session, I have a different view about this whole thing. I see deception in the system. I see a system where, in this same Nigeria, let's put it this way, we talk about corruption every day. And it's a country that actually encourages every Nigerian to be corrupt. Okay? If your minimum wage is 30,000 naira, and then that is not even buy the basics, or even take you to work, the transport fee to work in a week, then what are we talking about? We talk about elections. Every now and then, it has always been the same problem. Never have we seen any sanction. Where lies the ubi jus, ubi remedium principle of law? If somebody, messes with an election process and then is thrown out of office, that ends it. No sanction whatsoever. So what are you telling the people to do? Please get there by all means, become president or become governor. And then if you are lucky to throw you out, we would have gained something. So please do whatever you have to do. So for me, it's a no, the system has got to change. And our senators and House of Rep members, look at it this way. They are the ones making the laws. They are the ones that start to gain the process. So what are we talking about? I believe lawyers have a lot to do in this instance. We need to change this, the scenario. We really need to change things, turn things around. We need to speak out. We need to tell them that we don't like what they are doing. They just have to stop. Enough of the deception of people. That's what I feel about it.
Thank you very much. Please, I would like the next set of questions to come from the back. And if there are any students that are here, one question from you. Is that okay? Question from the back, please. Question from the back. None? The light is... You're recognized. Please go ahead. Thank you.
Thank you very much, Chair. My question, I have a question and a comment. And my question goes to Mazi Afamosigwe, SN. In his speech, he said that he would prefer a situation whereby judges in states handle election cases emanating from that state.
When did we start? Look at the time.
My question is, how possible? And don't you think, by so doing, it will endanger the lives of the judges? Bearing in mind what is happening in our political circle. Every day we hear one killing, somebody was shot dead, especially in Enugu State. If judges in a state should handle election matters that emanated from that state, I feel that it won't all go well with the judges. Number one, the politicians already know the judges very well. They know their local governments. They know their villages. They even know their clans. Don't you think that the lives of the judges and their family members will be at risk? And another thing, my comment again is this. All the panelists here mentioned, all blame the judiciary. But have we thought of the process that gave birth to the litigation? How many billions did the federal government release for the conduct of the last election? What happened at the end of the day? We are told to go to court. Something should be done to the process itself before we start blaming the judiciary. They told us that government spends so much because of the beavers. Did the beavers work? Were they used? What do we do to the electoral process itself before we go to the judiciary? Thank you very much.
Thank you, Betty. I think you're also suggesting that the judges in those states should not also handle cases against the government, even in off-election season. You see, you either be a judge or you don't be. You're suggesting that judges are cowards that can easily be intimidated. But I have faith in the judiciary. I have faith that the men and women who sit on the bench can dispense even-handed justice. And if we keep being afraid that, oh, the government will kill them, I am also not aware of any statistic that suggests that any of the judges have been subjected to electoral violence or been killed. And so I don't think we should hide under this fear. Now, the whole issue is about perception. Has the fact that judges are being moved to other states enhanced justice or fair perception that judiciary is doing well? And the answer, is not true. It's bad. Now, by we I mean the people in the streets, are permitted to be mad, to lose our heads. The judges are not supposed to. They are supposed to have a calm head and dispense even-handed judge. Decide the case is based on fact and the law. So we can't keep making these excuses. We can't keep saying, take them and continue to do the same thing all over when we see it's not working. We have to try something that works. We have to, like they do in order, if it means that the first 5 judges of the court should be the ones sitting, so that there should be no empanel where you pick and choose who sits. But we should be able to tell ourselves that the current system is not working. We must look for something that works. Yes, the process may be wrong. The politicians, the electoral umpire may be wrong. The courts are there to show them why they should not do the wrong thing. Why any person who does the wrong thing should face the law. We can't continue this way. We can't, Betty, we can't. Thank you.
Thank you. Thank you. Now we have one last question.
Mr. Chairman.
Yes.
As earlier directed, I have a question from a young lawyer here.
Oh, fantastic.
Thank you very much for the opportunity. Let me just go straight to the question. I would like to understand, right now we are already in a position where we are expecting the judiciary to give a good judgment on the election that we just had. I would like to know, if this judgment comes out and the people do not take it as a good judgment, would we say that the judiciary have done well? Because a lot of aspersions have been already there saying they don't expect the judgment to come out the way they want it from the populace. Would we have done the right thing if we give a judgment that the people will not embrace? That's just my question.
Thank you very much. But you didn't direct your question to any of the panelists. So Mr. Kwazom, SAN, will respond. Thank you.
Okay, I would like the SAN, Mazi, to help us answer the question.
That's because, well.
Thank you. I think the citizens don't have a right to pick and choose which judgments they respect or abide with. But because of executive recklessness, because of the continual erosion of the independence of the judiciary, and sometimes I always say, encouraged by the courts, in giving decisions that make their judgments unenforceable, or where the court fails to use its coercive powers to ensure compliance, their authority continually being eroded. There's a case I think you find interesting, AG, I think Attorney General and Time newspapers. That's a British case, where for commenting on ongoing proceedings in a court, the court invoked its powers to punish for contempt. Nigerian courts continually allow all manner of things to be said and done about their cases and decisions, and they do nothing. You get judgment, the court will subject it to the power of the Attorney General to issue consent. The courts are scoring own goals and weakening their power. Otherwise, no self-respecting politician or office holder will indicate that he will not or she will not abide with a binding decision of a superior court, or any court for that matter. Thank you so very much.
Thank you.
Thank you very much. I would like to very quickly give my thoughts on the question. And I think that no judge, when someone is made a judge, the oath of office that the judge takes is to do justice according to the law. And I don't think any judge should be worried or concerned about, except there's a legitimate basis for the public to reject a judgment, as in when a judgment is patently unjust, I don't think it should bother any judge about whether every segment of society will accept the judgment of the court. People are, partisan. People see things from their partisan standpoints, and there's no judgment that the totality of the people will accept. So what should bother a judge is there a legitimate basis for the public to reject a judgment that I have given, not whether any section of society is unhappy with the judgment. Thank you.
Thank you very much. I think, okay, one more person, okay.
Thank you, Mr. Chairman, Leonard Silk. Habib Dembo, the Wildlife Chairman, Kaduna Branch. A quick one, Mr. Chairman. Election cases are time-bound cases. So also other cases, such as enforcement of fundamental human rights. So also criminal cases, to which the ACJL was made to fast-track criminal cases. Now, I happen to be a victim filing an enforcement case, the time when pre-election acted. And at the Federal High Court, Kaduna, I wasn't even given a date. For my ex parte application, I wasn't even given a date. The judge said, he directed that he is not entertaining any other case except pre-election matter. Now, after election matter, we venture into election matter. While my own fundamental human right application is pending, which is also time-bound. They are taxpayers, while the politicians are taxpayers. They are all citizens, equality before the law. What do we do in such kind of situation? May I direct my question to any of the panelists at the discretion of the chairman? Thank you, sir.
Thank you very much. Dr. Okocha, please.
Thank you, Leonard Silk. Now, my response to your question. My opinion is that anytime you create a time-bound matter, or anytime the law establishes that the matter should be time-bound, what in fact we are creating is a bottleneck. Because if 10 cases arrive on the docket of a judge, 2 he is to hear within 30 days, 1 he is to hear within 180 days, he cannot share himself. That is the point I made during my earlier presentation, that no matter what classification you give to a case, whether election, criminal, commercial, man-hours are required to determine those cases. So, yes, it's unfortunate that certain categories of offenses are prioritized by virtue of statutes making them time-bound. However, the solution that I had suggested, if there were more judges, and it's possible to determine a matter in 15 days, regardless of whether it is enforcement or whether it is political, then it solves that issue. I hope I've addressed your point, sir.
Thank you very much. So I think we've finally gotten to the end of this session. But before then, I would just make a few comments. And the first, incidentally, is the one that was made by the chairman of the session when he talked about constitutional courts. I've looked very closely at the approach, the South African approach. And in fact, one of the fundamental questions that has been asked, I think, by all the panelists is, why do we have this many cases, apart from post-pre-elections, which is central to the topic? Generally speaking, why do we have this many cases? And I believe that it is primarily because, 1, attitude, 2, mindset. And although I think on this occasion we spent a lot of time talking about the either inefficiency of the courts and inability to manage cases. The fact that there's no magic. If you don't have enough judges, you cannot address these matters, you cannot dispose of them. We've had all sorts of laws. We've had all sorts of reports. I remember during the confab, we took time So indeed, if you're looking for solutions, they are there, they exist. They have been deliberated upon and agreed. And it has been based on consultation. But implementation is a different matter, which is why I totally agree that we should, at this time, have a constitutional court. Judges are trained for that purpose. That's what they're there for. And the selection of those justices or judges are also deliberate and intentional. But one of the areas I'm not sure I heard a lot about is the legislature. Every 4 years, there's a cycle of amending the Electoral Act. And it's purely in the interest of the people who will ultimately become respondents. So it doesn't matter if, and I think you are the same, or somebody did say that for a petitioner to overturn, for a petitioner to overturn the results is like going through the eye, it's like an elephant or whatever, going through the eye of a needle. I believe it is correct, but why is that so? When even the law to be interpreted is designed to protect the person who ultimately will become a beneficiary. I think everybody says we have to do something about this, we have to stop this. I think for me, the starting point is that we have to check. I don't know how, I haven't thought it through yet, but I don't think the legislature should be allowed to continue every 4 years to amend a law which is designed for their benefit. I think it's to me a fraudulent thing. I think it is fraudulent. Therefore, at this juncture, I would, there's a hand up, and I think you should speak. Please go ahead.
My name is Madaki Ame. I think we've had a very interesting session, but the point I want to make about the entire electoral process and the jurisprudence around it is also a disturbing trend about the way judges are appointed. If you realize that judges at the state level are appointed by governors, and judges at the federal level are appointed by the president, on the advice of the National Judicial Council and all that, we have a potential problem. Because the trend we have been noticing recently is that politicians tend to influence the appointment of their family members into the bench. And I think what they are doing is planning for the future, for when the petitions will come flying. So if nothing is done about the process by which judges are appointed, we are going to get into a state capture scenario where it doesn't really matter who is going to court, and they can arrogantly tell you, go to court, knowing that their daughter or their son or their relation is actually the judge you are going to meet. And so the bar needs to do something very drastic about it. Thank you.
Thank you. Before I get stopped, I think I have exhausted the time that we have been given. I want to thank each and every one of us that have been patient to listen. I want to thank the thank you. And please, is Mr. Tobin still on the? Well, even if he isn't, he will hear that we have all benefited from the presenters. And on behalf of the presenters and myself, I want to say thank you very much.